Well, good morning, Jaginder Rana here. The topic for our discussion today is non-delivery claim of cargo. Non-delivery claim of cargo. So the term non-delivery in marine cargo insurance refers to a situation where the whereabouts of the cargo is not known. So that is, the cargo has not arrived at the final destination named in the policy, untraceable even after vigorous persuasions, and the actual cause of non-delivery is unknown. The marine orders policy covers non-delivery of consignment unless specifically excluded. Our claim for non-delivery is not to be admissible if the whereabouts of the cargo is known or traceable. The cover for non-delivery of consignment is not available under any of the named peril clauses unless it is expressly covered against payment of additional premium. When the vehicle carrying the cargo is hijacked during the inland leg of a journey, and or if the whole containerized consignment has not arrived at the port of discharge, the loss is termed as non-delivery of entire consignment. However, when few drums or cartons or bales from an entire consignment are not delivered, it's termed as short landing and a shortage of packages unless the cover was granted for non-delivery of each and every package. So what is non-delivery of cargo in insurance parlance? Although neither the policy nor the Institute Cargo Clause nor the TPND, that is theft, pilferage or non-delivery clauses, nor even MI Act, Marine Insurance Act, provides any specific definition of non-delivery. There may be a doubt as to whether or the age-old understanding of non-delivery as failure of goods to arrive at destination without proof of cause of loss and when the whereabouts of the cargo is not known is sustainable in a court of law. While it is true that the theft, pilferage and non-delivery have not been clearly defined by the courts, references may be made to the important case law on the subject, Meadows versus Robertson. It may be mentioned that the term non-delivery cannot be viewed in isolation but has to be interpreted in the light of enumerated perils already appearing in, say, the SG form of policy or ICCB and ICCC. Then Meadows versus Robertson 1940-67 LR 484, while Hilvary J held that non-delivery was not itself an additional risk, rather the assured needs to prove non-delivery in circumstances consistent with the theft or pilferage, and that it was then for underwriters to show that the loss was caused by something for which they were not liable. So this interpretation in Meadows and versus Robertson case is accepted by Arnold's law of marine insurance and average. Non-delivery has to be understood as under in the context in which they appear in the policy. Say, if the cargo is short delivered at destination due to seizure by the customs authorities at an intermediate port considering the cargo as hazardous, it is lost by seizure, which is an excluded peril under clause 6.2 of ICC 1982 and not to be considered as non-delivery. So if the cargo is thrown overboard to save the vessel and or other cargo in the vessel under restrictions of the master of the vessel, the loss is to be termed as jettison. The consignment was not delivered due to commercial dispute between the insured and the carriers. This does not constitute non-delivery in the marine insurance context. The consignment was short delivered by the carriers but subsequently found to have been overcarried to a different port by the steamer company. Since the consignment was traced and we are at a different port, there is no valid claim for non-delivery under the policy. The consignment was not delivered by the carriers, and despite vigorous persuasion, the same could not be traced out. The insured is entitled to get non-delivery claim subject to furnishing a non-delivery certification issued by the carriers. If the vehicle along with the entire cargo is hijacked by miscreants, this may be considered as non-delivery of the entire cargo. So how to deal with non-delivery claims? When a non-delivery claim is reported, depending on the quantum and quantity involved, the underwriter should dispute an investigator cum tracer or investigation of the loss. For such investigation, especially for land transit, the underwriter should prepare detailed terms of reference based on which the investigator tracer is to carry out the investigation job. Such terms may include verification of purchase and or sale contract of the insured with their suppliers and or buyers along with payment particulars. So the stock register of the sender of the goods or insured on the date of dispatch of the consignment is to be verified to ascertain the stock position on the date of dispatch. Measurement of the individual's representative package should be ascertained to determine whether or not such bags or boxes or cartons have sufficient space to carry the quantity of cargo as mentioned in the invoice or challan. The number of packages needed for packing and weight of each package with cargo should be ascertained. So the vehicular documents issued by the carriers along with the invoice challan, excise gate pass of the goods issued by the sender, insured are to be examined to ascertain the details of the cargo actually dispatched. Date and time of removal of the goods from the factory and or warehouse of the insured sender. And any discrepancy is noticed, if any discrepancy is noticed in the documents, necessary clarification should be obtained from the sender. Verification of records at check post routes is necessary as the vehicle number is recorded in the check post or toll plaza. This should be verified to ascertain up to which point the subject missing vehicle and arrived. So the place from where the vehicle went missing can be identified. Investigations at the particular local area is to be undertaken for tracing out the missing consignment. The police station where complaint was lodged by the driver of the vehicle and or transparent company for missing trucks should be contacted, and their statement is to be recorded to determine the authenticity of the incident, and possibility of the recovery of the goods may also be inquired in. Any persons involved in the incident has been arrested, if so, under which section the particular case has been registered. The existence of the carriers and the authenticity of the transport document issued by them for carriage of the consignment should be verified. A statement of the driver, if available, is to be recorded. If the driver of the vehicle is absconding, a statement of the transporter is to be obtained as to when and by whom they were informed about the missing of the vehicle. A copy of FIR may be obtained from the carriers if no complaint was lodged to the police by the driver of the missing vehicle. It is to be inquired whether the carrier has lodged a complaint with the police, and if not, the reason thereof. If the carriers do not own the missing vehicle, it is to be ascertained from whom the subject vehicle was hired. Whether any steps were taken by the carriers for recovery of the goods, if not, the reasons thereof. Whether any commercial dispute between the insured sender and the carriers in terms of payments of freight, etc., existed, and if so, whether such dispute may have resulted in non-delivery of the consignment. So whether the freight for the subject missing consignment was paid to the carriers, withheld or adjusted from the security deposit, whether bank guarantee furnished by the carriers to the sender insured of the goods was invoked as per contract of carriage. If the insured is unable to furnish the consignee's copy of the consignment note because it was said to be missing along with the vehicle, a statement is to be obtained from both the insured and the carriers that the subject consignee's copy of the consignment note was submitted to the carriers along with the cargo for carriage. So the underwriters may obtain an indemnity bond from the insured for the missing consignment note. Other rights of recovery against the carriers are duly protected. Specific comments as to the authenticity of the claim loss with reasonable proof, particularly if the investigator concludes that the loss is questionable. So, non-delivery during the rail transit. If the consignment has not arrived at the destination station within a reasonable period, the consignee should present the railway receipt at destination station for necessary endorsement duly signed by the station master on the reverse of the RR. But the process is to be continued once a week for at least 6 weeks continuously if goods are not delivered. A non-delivery certificate should be obtained from the railway authorities and the original RR should not be surrendered to the railway authorities unless they issue a non-delivery certificate. In the absence of a non-delivery certificate, the original RR with qualification of station master will be the prime document to establish non-delivery of consignment. For the treatment of non-delivery claim under ITC B plus and theft, purpose and non-delivery clause. In India, it will be quite natural for the courts to decide cases on the basis of existing statutes. The Indian Penal Code distinguishes between theft and criminal breach of trust, where it has been proved beyond doubt that the driver of a lorry has disposed of the consignment without the connivance of probity of owners of the lorry. The matter may be regarded as a case of theft. However, if there is evidence of the carrier's probity, it would constitute a criminal breach of trust. Similarly, when the driver of the lorry is himself the owner and has issued the consignment note under his own form, the matter will also be considered to be a case of CBT. CBT means criminal breach of trust. Hence, if the cover is granted for basic risk plus theft, purpose and non-delivery risk, it is to be judged as to whether loss involved a theft or CBT. So, if it is a case of theft, then the claim will be tenable under an orderless policy with both criminal breach of trust and the theft are to be covered. In either of the covers, the loss will not come under the scope of the non-delivery clause. However, if the investigator fails to trace the goods out to the cause of the loss and it does not involve connivance or privity of the owner of the goods, the loss will be considered as non-delivery. Whether final police investigation report is mandatory for non-delivery claim. In case of non-delivery of an entire consignment, the driver of the vehicle should lodge a complaint to the nearest police station where the incident of the non-delivery has occurred. If such complaint was not lodged by the driver of the missing vehicle, the carrier should lodge complaint against the driver of the missing vehicle at the booking station. So the underwriter, while processing the claim, should ask the insured to furnish a copy of the FIR. However, the underwriters may not get final police investigation report from the carriers. The requirement for submission of a police investigation report may be waived where the report issued by the investigator confirms the authenticity of the loss beyond doubt. So, appointment of tracer and claim provisions, it is desirable that the intimation loss should be recorded in the claim intimation register through systems immediately on receipt of the claim advice. A claim file be opened immediately in such cases to ensure constant reviews every week and the insured concerned is to be pursued to find out whether or not the consignment has since been delivered. If the consignments are not delivered within a reasonable period, say within 1 month, or booking of consignment in case of road transit and at the end of the 3rd to 5th month, depending on the situation for rail transit, a tracer may be appointed. Provision for outstanding claim is to be made on the basis of intimation given by the insured. So, where liability has been admitted by the carriers, the provision should be for difference between the invoice value and the insured value plus a reasonable amount to take care of any possible litigation, recovery expenses. If the carriers go back on their admission of liability, sufficient time is available to take further recovery action on adequate provision or recovery. Thank you. Thank you very much.